Okay, great. Welcome, everybody. I'm Samar Shams. I'm an immigration and global mobility partner at Spencer West, and I'm delighted this morning to be presenting to you on sponsor duties. So the name of this webinar is Sponsor Duties. It's all fun and games until someone loses the right to work. This meeting is being recorded. So please do feel free to ask questions in the chat as we go. I'll try to check the chat as we go along and answer your questions as best I can, but be aware that the meeting is being recorded. And so don't put any confidential information in the chat. So today we're going to talk about, not to be able to move through. Sorry, I'm having an issue moving through the slides. So sorry, I'm having an issue with the slides. There we go. We're going to talk about the ramifications of a failure to comply with sponsor duties. We're going to talk about the duties themselves, what you can do to fulfill the duties, and I'm going to update you on how the Home Office is handling enforcement at the moment. So in terms of failure to comply with sponsor duties, you know, my style is not to scaremonger people, but it is important to be aware of the possible ramifications. So it seems that at the moment, a lot of companies are applying for sponsor licenses, much more than usual. There's been a real spike, and that's for a combination of reasons. So Brexit, COVID restrictions lifting, a really fierce competition for talent these days with the labor shortages. And so a lot of organizations are applying for sponsor licenses. The Home Office is overwhelmed and taking longer, unfortunately, to process them. But it's pretty evident that a lot of organizations are doing this without really understanding what they're signing up to when they apply to be a sponsor license, because you are pretty much entering into a contract with the Home Office where you're signing up to sponsor duties. And so the point of the webinar this morning is just to take a step back for those organizations that are thinking of applying for a license so that they understand what they're signing up for. If you already have a license, maybe you're not perfectly confident that you've been using your license correctly, that you've been meeting the compliance requirements. And so this is to give you confidence to make full use of your sponsor license, which today is crucial for remaining competitive in attracting talent. So let's talk about the possible ramifications. So if you don't comply with sponsor duties and you have a license, that license could be revoked. If your license is revoked, then the sponsored workers would have to leave the UK or find a new sponsor within 60 days. Certainly they'd have to leave your organization, and the organization might not be able to sponsor workers in the future. Depending on the reasons for the revocation, your organization might be ineligible to apply for 6 or 12 months, and certain people within your organization who had responsibilities on the license might not be able to act on licenses in future. Just continuing with the risks of non-compliance, if your license is being investigated, so the Home Office is asking for information and documentation whilst they decide whether to revoke as a possibility, then your sponsor license can be suspended whilst they're investigating. And if it's suspended, that means that you won't be able to assign new certificates of sponsorship. Often in this situation, you can assign certificates of sponsorship, which is the equivalent of work permits, basically, to existing sponsored workers, so people that you're already sponsoring. But you wouldn't be able to sponsor anybody new, and it's not clear that you'd be able to, say, sponsor somebody who was working at the organization under a different visa status to date. Now, again, I don't want to scaremonger, but there are criminal and civil penalties that might apply. People get very nervous about the criminal penalties in particular, and I think that's fair enough. But just to put it in context, the Home Office will only make use of the criminal penalties in the most egregious cases. So you really have to kind of not engage with them when they are corresponding with you about compliance for it to reach the level where criminal penalties would be triggered. Now, having said that, there is a trend in immigration enforcement to expand enforcement more broadly within the economy. So, basically not just targeting ethnic restaurants, and to make more use of the available criminal penalties. And now when I say criminal penalties, people, think immediately of a fine or jail time. And there is provision for that in immigration law. But there are other criminal penalties that you're much more likely to encounter. For example, the Home Office has the power to close the business premises. So an immigration officer can visit the premises and close and order it to be closed for, I think, 48 hours initially. Then they go to the judge, and the judge can order it closed for up to a year, or the judge could order, that right to work checks be done in a certain way, etc. And so those are criminal penalties that are more likely to apply. They are very serious. For a lot of companies, that would be the death of the organization if they're forced to close their premises for a year. But I would say really don't worry about jail time. Civil penalties are very likely to be applied, and those can be £20,000 per instance of illegal working. And we'll talk a bit later about how easily that can come about, actually. If you don't mind now, I'd just like to take a poll that will help me to understand what you would like to learn during this webinar, so that I can act accordingly and best address your needs. So if you wouldn't mind responding to the poll as to whether you have a license or not, it will help me to give you the best webinar experience possible. I've got some people who are just curious, people after my own heart. Okay, I'm just going to give it a couple more seconds and then I will close. All right, so I'm going to end the poll, and just to share the results. Looks like most people here already have a sponsor license, which is really useful to know. And others are just curious, which I love. So thank you for that. Let's talk about, or let me ask you to consider what the potential ramifications are for your organization specifically if your license is revoked. So it seems most people here are, have some duties relating to the sponsor licenses of their organizations. So have a think. Who are your sponsored workers? Who might be at risk of having to leave the company? What would be the effect on, servicing your own clients, your business plans, your growth plans, and what might be the effect on some of the responsible people on the license of not being able to fill those roles in future? What would be the effect on the organization of not being able to sponsor non-UK nationals to work? So just have a think about how it might affect your particular organization. None of us want to be in this meeting that's pictured here. That does not look like a fun meeting, but that's probably, the meeting that would result if the Home Office decides to revoke a license. So All right, now let's shift gears to a more positive perspective. Let's talk about the actual duties. So you know what you're dealing with here, and none of the civil and criminal penalties are ever going to apply to you because you're going to know exactly what's expected of you. Now, I'm not going to cover every single sponsor duty here. I'm going to cover off the main ones and discuss a few that are maybe misinterpreted or give particular trouble to sponsors. So what are the sponsor duties? Oh, are you guys not following these slides? Sorry, I've moved on in the slides. This was the picture. Maybe you couldn't see it and didn't know what I was talking about, but this was a meeting I was talking about that nobody wants to be in. And now let's talk about the duties that sponsors have. Sorry if that wasn't working. Okay, so there are three main types of duties. There are compliance duties, reporting duties, and record keeping duties. Now, compliance duties, that might seem redundant because, you know, all of this has to do with compliance. But when the Home Office says compliance duties, what they mean is that you are basically assigning work authorizations in the way that they want you to, in line with their policies. Because if you stand back and think about the framework of sponsorship in the UK, you realize that basically the government has passed the buck to organizations to assign their own work permits, okay? So the government used to assign work permits. You would apply. In my youth, I would apply on behalf of companies for work permits, and the government would approve them. And then the individual would use that work permit to apply for their visa. And now instead, the government has passed the buck to employers. They apply for sponsor licenses, and that authorizes the employers themselves to assign certificates of sponsorship, which are the equivalent of work permits that the individuals use to support their visa applications. So the Home Office, because they're granting this really powerful function to employers, then rely on you to only assign work authorization in a compliant manners, in line with, you know, how they want you to do it. So that's really what's meant by compliance duties. And I've listed some of the main points here. So the worker has to be appropriate for sponsorship. Okay, that means that they have the ability to fill the role, they're intending to fill the role. And we'll look a little bit more at how you can verify that later. But, you know, basically you need to ensure that they have the experience, skills, and qualifications required for the role, okay? Now, they must only be allowed to work in the role that is specified on their certificate of sponsorship, okay? I'm going to say this again. A sponsored worker is only allowed to work in the role that is specified on their certificate of sponsorship. This is the compliance duty that is most often disrespected. And it's usually because a worker's role will change after assignment of the certificate of sponsorship, and the sponsor won't do anything about it. We'll talk a little bit when we discuss reporting duties, what needs to be done in that case. But I just want to underline this point because it's very often overlooked. Okay, and then other than the individual being able to fill the role, and meeting the requirements, the role itself has to meet certain requirements. So it has to meet salary, skill level, and genuine vacancy requirements. Now, in terms of salary and skill level, many of you will know, as you have sponsor licenses, that the immigration rules include a list of all of the roles that are deemed to meet the required skill levels for the skilled worker visa route and for the intracompany transfer visa route, which is a higher skill level requirement. And so you need to identify the correct standard occupational classification or SOC code for the role that you want to sponsor someone for. And there is a tool on the Office of National Statistics website, the ONS website, an occupation coding tool. This is all written down in a later slide, so don't worry about furiously taking notes or trying to remember what I'm saying here. But that is how you will know whether the role meets the skill level requirements for the skilled worker or intercompany transfer route, by identifying the appropriate SOC code and finding that in the list that's published in the immigration rules. That list will then also tell you what the salary requirements are, okay? And you will have to meet those salary requirements for each role. So in terms of genuine vacancy, okay, genuine vacancy is an awfully wishy-washy term, one of these terms that the Home Office makes up. And I'm very proud of myself, I have to say, for having been involved in a feedback exercise to the Home Office, where we forced them to define this term a little bit better, at least, okay? But it's still not great. Basically, the genuine vacancy requirement means two main things. One, you're not sponsoring somebody for a role where most of the duties are actually going to be at a lower skill level than what is required. So any job is going to have several tasks, duties, and responsibilities involved. What the Home Office doesn't want to see is that most of the tasks are at a skill level that doesn't meet the requirements, and maybe one or two meet the requirements. What I achieved, what I'm so proud of myself for, is that the Home Office took on board my feedback that you must allow for some lower skilled tasks in any role, because previously the genuine vacancy requirement prohibited any lower skilled tasks being involved. And we've all paid our dues. There's so many small businesses now, manager directors who are doing, a lot of admin. And so that definition didn't really work. So they've adjusted it slightly, but you still mustn't have somebody performing mostly lower skilled tasks when you're sponsoring them for a role. So that's one element of genuine vacancy. And the other element has to do with the Home Office wanting to ensure that you're not creating a role just to facilitate somebody coming to the UK, okay? That's what they mean by genuine vacancy. And so if you're related to somebody, you have to, somebody that's being sponsored, if they're related to somebody in the organization, you might have to report that. That's where advertising comes in. Although it's no longer required, it can be a factor in the Home Office assessing that the vacancy is genuine. And another point, and this one I think I've delightfully animated for you because I wanted to underline it, is that you must only assign defined certificates of sponsorship and undefined certificates of sponsorship as appropriate in particular circumstances. Now, underline this because, interestingly, the Home Office, I don't know if many of you have been on the sponsor management system lately, but the Home Office published a notice on the sponsor management system that you might have seen. Basically, it's a plea to sponsors to only assign defined and undefined certificates of sponsorship in the correct manner. So again, as I said, it's evident that a lot of sponsors are not doing this properly. Now, this defined and undefined certificates of sponsorship used to be called restricted and unrestricted. And in that time, it was a lot more complicated. It's actually pretty simple now to know whether you need a defined or undefined certificate of sponsorship. It's as follows. If you are assigning a certificate of sponsorship to a skilled worker who's going to apply from overseas, you need a defined certificate of sponsorship. If you are sponsoring a skilled worker or an intercompany transfer worker in any other circumstances, then you need an undefined certificate of sponsorship. Okay, so anybody applying from within the UK gets undefined, and intercompany transfer applicants from overseas get undefined certificates of sponsorship. Also ensure that any intercompany transfer workers are have the appropriate length of service overseas. So for the main intercompany transfer route, that they have to be employed by the overseas linked entity for at least 12 months. Okay, any questions before I move on? You can pop them in the chat. No. Okay, do let me know if you have questions. Let's move on to reporting duties. So this is where most of you will be interacting with the sponsorship system and the sponsorship management system on a day-to-day basis, okay, is where you have to report certain events. Some events relate to the workers, some events relate to your organization. So in terms of workers, most events that have to be reported that relate to workers have to be reported within 10 days of their occurrence, okay? And those include if the sponsored worker is absent on the first day of work, and that could be for a benign reason like they missed their flight. Very often it is because of delays in the visa processing. So if you entered a start date on the certificate of sponsorship and that changes before they actually start work, you need to report that. There are some restrictions on how far back you can push it, but I won't go into that now because it's quite complex. But if you need advice, do get in touch. Then you have to report if a sponsored worker is absent from work without permission for 10 days or more, 10 working days. You have to report if their sponsorship is terminated early, if their employment is terminated early. And you have to report changes in the details of their role, okay? So if their job title changes, if some of their core duties change, if their job location changes, or if their salary is reduced, you have to report that via the sponsor management system. Now, a couple of points I want to highlight in terms of reporting changes to the job details. First of all, if the job changes significantly enough, then you actually would have to assign a new certificate of sponsorship and have them apply for a new visa in line with that certificate of sponsorship. And when I say if the job changes, significantly or substantially, I mean that it moves to a different standard occupational classification code. So remember we discussed that you look up the job on the in the immigration rules and you see which standard occupational classification code it best matches. Well, if that changes, then actually you will need a new certificate of sponsorship and a new visa application for the individual. In terms of job location, this has been a really hot topic lately with remote working during the pandemic and now the move to more hybrid working. So the sponsored workers' regular job locations, so job locations that they're attending regularly, they should be listed on the certificate of sponsorship. And, if they are working from home regularly, say, Wednesdays and Fridays, then that should be listed on their certificate of sponsorship. And keep in mind then that if they move home, you're going to have to update that. The office, the organization's office location should also be listed. Note in terms of salary, reporting salary changes, that increases to salary are no longer required to be reported, regardless of the reason. So it used to be that, increases in line with annual raises across the board didn't have to be reported, but other increases did. And now you don't have to report any increases. It's just salary reductions that have to be reported. Of course, whatever salary reduction action you might take, you need to be conscious that you're not falling foul of the minimum salary requirements if you do reduce the salary. Okay, so I hope you've all been paying attention because it's now over to you. Your organization employs a lady named Sophia in the UK. She's hired as a software developer under the skilled worker route for 2 years. Sophia's visa application is delayed and she starts work 2 weeks later than planned. What action, if any, does your organization need to take? Answers in the chat, please. What do you need to do if the start date is delayed? Yes, very good. Bruno, Anna, and Kazia, and Alexis. Oh, sponsor note, interesting. Notify the home office via the SMS. Yeah, very good, everybody. You need to report the change in the start date, okay? Now, Alexis mentioned that you should report it via a sponsor note. And that could be the case. But a sponsor note is only valid if a sponsor note is only the means of reporting if the applicant has not yet used the certificate of sponsorship in their application. So they haven't yet submitted their application. Otherwise, you will have to just report. It's a different form of reporting, basically, and it counts as reporting activity. It's basically stored in a different section of the SMS. But in either case, you know, whichever way you use to report it, it does need to be reported. And it has to be reported within 10 working days of the event, which means 10 working days of passing the original start date, I would say in this case. And then if you do that, then you don't really have to worry about, you know, absence for 2 weeks, reporting that, absence for 10 business days, because you've already reported that it's actually a different start date. Okay, now, 3 months after starting work, Sophia receives a promotion. What action, if any, does your organization need to take? Answers in the chat, please. She receives a promotion. All right, we have some answers. Bruno, you are good. Bruno has said no action required unless the SOC changes. Change of employment, SMS, update salary change. Alexis, report the salary change. Kazia. Very good, guys. So, you know, really good answers. Basically, what I would say here is, you know, assess whether the SOC code is changing. If the SOC code is not changing, it doesn't necessarily mean that there's no action to take. You know, if the promotion involves a job title change, or a salary change, as Alexis and Kazia have pointed out, then both of those would need to be reported, even if the SOC code doesn't change. Okay, so if the SOC code changes, we're going to need to assign a new cause. If not, if the promotion involves a job title change, or changes in job duties as well, or salary changes, then that job title change, changes in job duties, and salary changes, those would all need to be reported. Okay, now after all this, Sophia decides to leave after 6 months. She hands in her notice. And what action do you guys need to take? Report salary change. And Candace says retain her information details for at least 2 years. Interesting. Okay, so report salary change was in relation to the last one, actually. So you have to report in this instance, the termination of sponsorship. In terms of retaining details, there's a difference between how long you have to retain right to work documentation and how long you have to retain records of sponsorship according to Appendix D in the sponsor guidance, which sets out what records of sponsorship are required. We'll look at reporting requirements, record keeping requirements in a bit, but the main point here is that you have to, as Alexis says, you have to report the cessation of employment via the SMS. Really great, guys. Thank you. It's nice to know that you're out there paying attention and engaging. Thank you so much. So just some final words on sponsor duties. Not all the sponsor duties relate to the worker. As I said, some sponsor duties relate to changes to the organization itself, okay? And these are really often overlooked, and these can lead to, multiple instances of illegal working at one fell swoop, because basically what happens is that one business is sold to another, and the change isn't reported, and people end up working for, as Alexis has said, 2P situations. It might be a 2P situation. People end up working for a different company sometimes than those that are listed on their certificate of sponsorship. Obviously, then they're not actually working in line with the details on their certificate of sponsorship, and technically that is illegal working. So if there is a sale of the business, if your controlling owner changes in particular, then your organization might need to surrender its license and apply for a new one. And it's really counterintuitive and very, very annoying to have to go through the whole process. But it does make sense in that when you apply for a sponsor license, the Home Office investigates, who is responsible for the license. They research the company, look at, who the owners are, et cetera. And so if that changes, all of that needs to be reevaluated. Now, these situations can be very complex, and they're very case specific. Alexis was great to raise the point of whether 2P applies, because whether 2P applies or not will change exactly what you have to do in the circumstances. But for our purposes today, I just want to flag to you that any kind of corporate restructuring can trigger sponsor license, sponsor duties, reporting that needs to be done. For changes to the organization, the reports need to be done within 20 working days. So you have a little bit more leeway. But don't forget, please don't forget sponsorship in corporate restructurings. Okay, I'm going to move on to record keeping duties. So you have to keep a copy of the worker's current passport. And as I said before, these record keeping duties are set out in Appendix D to the sponsor guidance, FYI. And for records kept under Appendix D, you have to keep them for 2 years after the end of the individual's employment. It's different for right to work checking. But in any case, yeah. Just trying to think if I'm confusing the two. I'll get back to you on that. So for one of them, it's you have to keep them for 1 year after the employment has ended, unless an immigration compliance officer checks them earlier, in which case you don't have to keep them beyond that. And otherwise it's 2 years. I'll double check and get back to you. So you have to keep a copy of the worker's current passport. Now, if you have somebody that you've sponsored and they've applied from overseas, you have to keep a copy of the wet ink entry stamp that they got when they entered the UK. Okay. If they don't have an entry stamp, then view some other evidence of when they entered the UK. And then record the date of entry. You don't then have to keep the evidence of the date of entry if it's not a wet ink stamp in their passport. So the travel tickets that you viewed to verify the entry date or the boarding pass, you don't have to keep those records on file, but you do have to record the date that you verified. Okay, now let's do a little poll, please. Move on to the next poll. So, why do sponsors have to verify the date of entry? Please tell me. Is it because they need to establish a statutory excuse from civil penalty for illegal working? Is it to verify that the individual's visa has been activated? Or is it because admin is fun? Just going to let a few more people answer. Nobody's voting for admin is fun. Well, good thing you're not immigration lawyers. Okay, we've got a bit more than half the people having participated. Does anybody else want to participate before the polls close? Last chance. Please do. Oh, we've got more people coming in. Okay, so I'll share the results. Most people have said that it's to verify that the individual's visa has been activated. And this is the best answer. So let me backtrack and explain a bit. When you, when a worker applies for a visa and is granted a visa, they then need to travel to the UK within the period of validity of that visa to activate the visa, so that when they are in the UK, they're in the UK under that visa status, okay? Now, how can this go wrong? Well, basically, there are a number of nationals that can enter the UK without first needing a visa, so they can enter as visitors, where they just rock up to the border and they don't need a visa. And so if, you know, for example, a US national, if they enter the UK before the start date of their visa, then they're entering as visitors. And if they start working, then they're breaching the conditions of their leave as visitors, because they've never activated their visas. Now, to establish an excuse from civil penalty from illegal working, pretty good answer, but you know, those requirements, the document checking requirements are very, very specific. So it's not really a great general answer that this would establish the statutory excuse from civil penalty, having the wet ink stamp in the passport. So I hope that was helpful. Do let me know if you have questions about that or are still confused. You need a copy of the biometric residence permit card if they have one, and you need a copy of their NI number card or their NI document. You need something with their NI number on. Okay. Right now, we all know, or I hope we all know, that advertising is no longer required for sponsoring skilled workers. Hallelujah, it was so annoying doing all those screenshots and ensuring 28 days had passed. So that whole dance is over. Nevertheless, if you did advertise the role, then there are certain record keeping duties that are triggered. So you have to have on record details of the advertisement. So that includes some kind of copy of the advertisement, okay? And the Home Office, if they visit, must be able to verify, you know, where the job was advertised, okay? So which platform, which website, and to know the start and the end dates. You also need to keep a record of the number of people who applied, the number of people who were shortlisted for interview or for, you know, another sifting stage of recruitment. And you need at least one other document, okay? Now this can be the interview notes of the successful candidate. It could be the list of interview questions that you used on everybody who applied, that you asked of everybody who applied, or it could be evidence of the scoring or grading process that you employed to identify the correct or to identify the successful candidate, okay? So I'm just going to, just going to ask you to please let me know. Oops. I'm going to do another poll, please. It's actually a quiz question. So you advertised the role for which you're sponsoring a skilled worker. Okay, you didn't have to, but you did. Which of the following must you retain in relation to unsuccessful candidates? Do you have to retain the application forms? Do you have to retain the CVs, interview notes, name and full contact details, all of the above or none of the above? What do you think? Got some saying all of the above, some saying none of the above. One vote each for interview notes and name and full contact details. One vote for application forms. Would anybody else like to vote? Oh yeah, some people still coming in. Okay, I'm going to end the poll now, and I will share the results. So the answer that got the most votes was all of the above. In fact, the correct answer is none of the above. Okay, let's look again at what you have to retain on record when you've advertised a role. The details of the advertisement, the number of people who applied, the number of people who were shortlisted, and at least one other document. So interview notes in that case, in this case of the successful candidate, or the list of interview questions that you asked everyone, the scoring or grading process, or some other document relating to how you assessed candidates. You don't need to keep everybody's application forms. You don't need to keep their CVs. You don't need to keep unsuccessful candidates' interview notes or even their names and contact details, okay? You just need details of the advertisement, numbers of people who are engaged in the application process, and some documentation of the assessment, okay? It used to be very different, so it's fair enough that you would think more is required, but happily, it's not. Let's say you didn't advertise, okay? And this is a tricky situation now for a lot of sponsors, because they got rid of the advertising requirement relatively recently. We're not sure what to have on file if we didn't advertise. Well, you have to have some kind of documented explanation of why you selected the person, okay? And if they've worked for you remotely overseas or under another visa type from within the UK, you can discuss their, excellent performance in their roles with you to date. Maybe there was a different type of recruitment process entirely where there wasn't a vacancy posted. They made a speculative job application and were ultimately successful. Maybe you conducted milk rounds. That's where you go to universities and present on your company and maybe interview students at their universities. Whatever it is, it has to be really well documented. And has to make sense in terms of why you chose the person that you did. Okay, so just going to move on. Let's do another quiz question, please. Oh, sorry, we did that already. Okay, record keeping duties in terms of skill level. What do you have to have on record to show that the job meets the skill level requirements and that the candidate, the sponsored worker, meets the skill level requirements. So you have to have the job description on file. It has to be fairly detailed. Have their degree certificates and professional qualifications on file, if any are required for the role. Have the evidence of required experience. And again, I'm highlighting this because I do often hear of people being sponsored without their sponsor having requested evidence that they have the minimum number of years required to fill the role on file, which would really best come in the form of reference letters from previous employers. Now, if there's some kind of legal requirement for a registration or a professional accreditation for somebody to fill a role, then really you need to have that on file as well. There are ongoing record keeping duties. So you have to keep sponsored workers' contact details on file. Sorry, Alexis has made a comment about requiring evidence of English language ability on file. For skilled workers, that is required. There are a number of different ways to fulfill the English language requirement. But yes, thank you, Alexis. And so in terms of record keeping duties that are ongoing during sponsorship, the history of contact details has to be on file, as well as the current contact details. So just make sure whatever system you have is not overwriting their previous contact details. You have to have a system of recording absences. You have to keep their pay slips on file or be able to access them, if requested. You have to have evidence of salary payments. Now, lots of organizations use payroll providers, etc. But basically you need to provide a chain of documentation that shows that the money left the organization's account and went specifically into an individual's account. So, just providing bank statements of the company that say, salary payments is not sufficient. And again, this is documentation that the Home Office will, they'll consider you compliant as long as you're able to provide it within, say 5 working days should they request it. So it's not like you have to continuously update the personnel files to have these, but you do have to be able to access them quickly. I also recommend keeping on file details of the certificate of sponsorship so that it's very easy to see whether the other documentation on file is sufficient. In terms of what the job duties are and the salary requirements, etc. Okay. You have to keep the contract of employment on file. It has to have the names and signatures of all parties. It has to have the start and end dates. Now, end date is often missing from a normal employment contract, but the Home Office wants to see end dates in for sponsored workers. So you can put an end date of the end of their visa expiry and say something like this can be renewed subject to right to work continuing, but they do want to see an end date. It has to have the details of the job, the hours, and the salary. Okay, so I'm quickly going to address where a sponsored worker is working on a client contract. So this happens in specific industries like tech or construction, but also in other industries where basically, your sponsored worker is servicing a client that you're contracted to provide a service to. Now that's fine, but there are certain restrictions that have to be met. So the work has to be for completion within a specific time period. The sponsor still has to remain responsible for the duties, the functions, and the outcomes of the role. And basically, it cannot be that you're just hiring somebody out or they're filling a routine role for another organization that's not the sponsor. The client's address should be listed on the certificate of sponsorship, as well as the sponsor's office address. There should be a statement of work, an overall general statement of work between the two parties that specifies the end date of the project. And any of your agreements with your clients should include a provision that highlights that the Home Office might come to visit their premises, for example, to interview the sponsored workers. Okay, so we've talked about what the duties are. Let's talk about how to fulfill them. Now, this is going to be different for each organization. Consider what systems and documents you have in place. Which duties fulfillment depend in whole or in part on you? What are you doing to ensure those duties are met? Which duties depend in whole or in part on others? So, for example, the sponsored workers themselves, they have to be giving you their contact details, updating you with their contact details if you're going to make, if you're going to keep the necessary records on file, and in cases of home working, make the necessary reports to changes in job location. You know, some things will depend more on people within your organization. So, you know, keeping track of visa expiry dates and diarizing for those kinds of things. Now, what I want you to think really hard about is how you would evidence your systems to the Home Office, right? If they ask you to share documentation of how you're fulfilling these duties. Now, it might be that in fact, you know, you have a great memory and you're making all the necessary reports, etc. But if you can't demonstrate to the Home Office through your diary systems, through your documentation, that you have the systems in place, then they very well might take action against you. So keep that in mind. So some things you might consider putting in place are a new joiner checklist. That could cover things like the right to work check and evidence that that's done before they start working. It could tick off that they've checked the employee handbook, which states that they have to keep you updated with their contact details and immigration status, or wherever, you know, that those duties to the workers are. You might have an ongoing duties checklist attached to each sponsored workers file to help you ensure that everything's on there. Your template employment contract, your handbook, your offer letter, those all have to have provisions for various people fulfilling the requirements so that you are able to perform your sponsor duties. You'll probably need spreadsheets and diary systems for keeping track of visa expiry dates, absences, etc. And the job descriptions of those who are level 1 users or authorizing officers, those should reflect their sponsor duties, their responsibilities in maintaining sponsor duties. Now, one thing that's really tricky and coming up a lot is monitoring attendance and tracking workers' locations, because this is one of those things that best practice HR does not necessarily tick off. So a lot of the sponsor duties are actually ticked off by, you know, normal HR practices or best HR practices, but this one isn't. So we'll do a quick poll. We're running out of time, but I'll do the last poll on how you might monitor and track workers' locations. It's basically, you know, if the Home Office shows up, you need to be able to tell them where your workers are. So what do you think? How do you monitor attendance and track workers' locations? Okay, very interestingly, we very quickly got votes for all three. It could be attendance software, diarized daily team meetings, daily phone call and attendance note. Okay, any more votes quickly? Thank you. All right, the poll is closing. We got votes across the board, and that's great. Any of these would be fine. The Home Office just wants to see something, okay? You know, as long as you're able to tell the Home Office who is where on any given day, that's fine. You know, attendance software might be able to do it for you. A diarized daily scrum or team meeting, you know, where you would see if somebody's absent and people will tell you, oh, I'm going to this site, I'm going to this client location every day, or tell their line manager who then records it. or a daily phone call and attendance note, with the level 1 user or person responsible. Any of those could do it. Okay, I'm quickly going to talk about how the Home Office is conducting compliance visits now and conducting enforcement now, which is very interesting. So because of COVID, they basically, in practice, stopped visiting sponsors in person, or at least I haven't heard of any visits recently in person. And they've taken to conducting compliance visits basically by correspondence. So very often now when an organization applies for a license, or maybe applies to renew a license, or one of the other triggers come up for a compliance check, then the Home Office will write to the sponsor and ask them to provide documentation of their systems, usually within 1 week, which is not a lot of time to evidence all the systems that are required. So just based on some of the documentation of these that we've seen, I've put together some information on what you can expect to be asked for in this type of compliance check. So they're going to ask for any information and evidence of the HR systems. And that can be, Word, Excel. They ask for screenshots. And they want to see that the systems exist, but they also want to see that the systems are being used. So, you might have a very beautiful spreadsheet to record absences, but there's absolutely nothing in it. And that is not going to fly with the Home Office. They want to see that you're monitoring immigration status. So they're going to look at your right to work checking processes, your system for recording visa expiry dates, and the records that you have on file for particular migrants as well. So they'll look at the systems as a whole, and then they're going to ask for examples relating to particular sponsored workers. They'll look at how you're maintaining the workers' contact details, visa expiry dates for current employees subject to immigration control. And, again, that can just be a spreadsheet and a diary system, that's fine, but it needs to be in place and it needs to be used. They'll look to see that you have the documentation of the national insurance number that we mentioned, and a sponsored workers' skills, qualifications, and experience to match the role that they've been sponsored for. So a registration certificate, if that's legally required to do the job. So for example, a doctor or a nurse would require that. Degree certificate, if that's a requirement of the role. And then letters of reference, ideally, that document the years of experience required, if there are any years of experience required. Or at the very least a CV, but really I would recommend letters of reference because they're independent. Okay. So in terms of recruitment, what they're looking for is that you've identified the correct standard occupational classification code, the SOC code, and I promise that the SOC code information would be written on a slide. So here it is. You look at the immigration rules, look at appendix skilled occupations of the immigration rules to identify the SOC code, and you can use the ONS occupation coding tool to search by keyword to help you identify the correct SOC code. Once you've done that, verify that you are meeting the salary requirement. And in terms of advertisement, you'll have to have the details of the advertisements that we discussed, including, the website or platform and the date, the copy of the advertisement, and that one other document relating to the process that we discussed. They're also looking for the job description. So everything we discussed, but I've just set it out in terms of how they're asking for it in the correspondence. They want tracking and monitoring systems that are demonstrable. So again, a daily attendance sheet, spreadsheets, and how you're tracking at different job locations. That's one thing to keep in mind if people are moving about. Right, so with 1 minute to go, we are done. Thank you so much for attending. Does anybody have any questions before we sign off? I was going to tell you about the right to work, how long you have to keep documents. So I'll just look that up quickly whilst I wait to see if anybody has questions. Please do just pop them in the chat if you have any questions. Otherwise, I will expect you all to be beautifully compliant. Okay, so for the documentation of sponsorship, those are the ones that you have to keep until 1 year after the employment or until an immigration officer checks them. And it's the right to work documentation that has to be kept for 2 years. So I hope that's clear now. Okay, it doesn't seem like there are any questions that have come through. Thank you so much for joining today. I had fun. I hope you did too. And hope to see you at the next one. Oh, there's something in the chat. Oh, just a thank you. You're very welcome, Kezia. And thank you for coming. All right, take care, everyone. Oh, it's my pleasure, everybody. Thank you. Thank you for joining. It's my pleasure. Take care, everybody.